Okay, let's get started. We're digging into some really interesting material today. Sources made available by the University of London for students.
Yeah, it's great they provide this.
Absolutely. Big thanks to them. And just so everyone knows, this deep dive, it's purely for educational purposes.
That's right.
And we're happy to say it's brought to you by Sinorbit Academy, Sri Lanka.
Good stuff.
So for everyone listening, especially if you've got exams on the horizon, really good luck.
Yes, best of luck.
Our plan today is to unpack the core ideas, the real essentials, from this material on restitutionary remedies in conflict of laws. We're focusing on, well, unjust enrichment, trying to help you really get a handle on this for your studies.
And it's quite a topic because, the law of restitution, particularly with conflict of laws thrown in, it's still developing quite a bit.
Right, not as settled as some other areas.
Exactly. Compared to contract or tort, the rules here, they're just less, well, fixed. That creates challenges, definitely.
Okay, developing area. So complexity is part of the game. And the material, it really flags that the first big step, the absolute starting point is characterizing unjust enrichment.
Crucial.
Why is that so fundamental, getting that characterization right?
Oh, it's everything, really. You absolutely have to characterize the claim correctly to figure out which set of conflict rules even applies.
Oh, okay.
Because an unjust enrichment claim, it might look a bit like a contract issue or maybe a tort claim or even something rooted in equity.
I see.
If you get that characterization wrong at the start, you could end up using completely the wrong choice of law rule. The whole outcome could shift.
Wow, okay. So that first step dictates the path forward. The sources mention the common law way of doing this, in that case, Macmillan, Inc. v. Bishopgate Investment Trust.
Yes, Macmillan Inc. v. Bishopgate Investment Trust, that's the one, from 1996. It's a key English case showing how the courts traditionally approached characterization for claims, some of which we'd now clearly label as unjust enrichment. But, and this is a really important point the material makes, when you're dealing with the Rome II regulation, you can't just look at it through that old English common law lens.
Why not?
Because Rome to Sec is, well, it was an EU instrument. Characterization for its purposes needs a broader view, an autonomous interpretation, not tied just to one country's historical approach.
Okay, that's a critical distinction for, anyone studying this. Don't just default to the English view if Rome to second is involved.
Yeah.
Which brings us neatly to the Rome II regulation and Article 10.
Precisely. Rome II regulation, Article 10. This article creates specific, special choice of law rules just for unjust enrichment claims. It gives some much-needed structure.
So it tries to clarify things.
It does. Interestingly, though, Article 10 gives an example like recovering payments wrongly made, but it actually doesn't define unjust enrichment.
Oh, so it tells you the rules but not what the term means.
Kind of, yeah. The concept itself, what counts as unjust enrichment, is left for the national laws being pointed to. And remember, even with Brexit, these Rome II rules, Article 10 included, they still apply here in the UK.
Right, because of specific UK regulations keeping them in place. Good point.
Very relevant still. Now, this Article 10, it lays out 4 rules, basically, to find the applicable law. The first one highlighted is for claims linked to an existing relationship.
Like a contract that went sour or a tort?
Exactly. If the unjust enrichment claim arises from and is closely connected to, say, a prior contract or tort between the parties,
All right.
then the law that governed that relationship, the contract law, for instance, often governs the unjust enrichment claim too. Keeps things tidy, legally speaking. A closely connected relationship is key there.
Right. Avoids applying multiple different laws to related issues. Makes sense. But what if there isn't that kind of close prior connection?
Well, that's where it often gets more complicated. We look to the default rule. That's Article 10.3. It states the applicable law is the law of the country where the unjust enrichment took place. Let's repeat that. Article 10.3 points to the law of the country where the unjust enrichment took place.
Where it took place. Okay, sounds simple enough on the surface, but I'm guessing it's not. How do you pinpoint that country in a cross-border case?
You've hit the nail on the head. That is the major challenge with Article 10.3. The place can be really ambiguous.
How so?
Well, think about it. Is it where the act happened, where the benefit was actually conferred, or maybe where the claimant became poorer, or is it where the defendant actually got richer?
Yeah. If money moves electronically from country A, enriching someone in country B, causing a loss in A, Where did it take place?
Exactly. There are several possibilities. The material mentions that academic sources like Cheshire, North, and Fawcett tend to favor the country where the enrichment occurred, noting some German law influence on Article 10 here.
Okay, so there's academic debate trying to clarify that ambiguity. What about the last rule?
Right, there's a bit of flexibility built in. It's Article 10.4.
The escape clause, I think they called it.
That's the one. Article 10.4 allows a court to apply a different law if it's clear the case is manifestly more closely connected with another country.
Manifestly more closely connected. Sounds like a high bar.
It is intended to be, yes. It's a safety valve for unusual cases, but exactly how courts interpret manifestly more closely connected, well, it's still being worked out in practice.
Okay, let's pull this together then, thinking about those study questions. We've seen characterization is vital because it decides if Rome II Article 10 even applies, right?
Absolutely, step one.
And the difficulty in having one simple rule for unjust enrichment stems from, well, the term not being defined in the regulation, and especially that tricky issue under Article 10.3 of locating where it took place.
Precisely. Those are the core issues. For exams, you really want to lock down those concepts.
So remember characterization. Remember the Rome II regulation, Article 10, and its structure, especially Article 10.3 and Article 10.4.
Don't forget the Macmillan case for the common law context and why the regulation's approach differs.
And understand that central problem, locating the place of enrichment under Article 10.3. Got it.
Nail those points, and you'll be in good shape.
Excellent. Understanding unjust enrichment in conflict of laws is clearly pretty essential for this subject area.
It really is.
Okay, massive thanks again to the University of London for the source material
Indeed.
and to Sinorbit Academy, Sri Lanka for bringing this deep dive to you. And one last time, for all of you studying, the very best of luck with your exams.
Good luck, everyone.
And maybe a final thought to chew on as you revise. Think about that Article 10.3 problem where the enrichment took place. If you had a complex case with connections to multiple countries where the event happened, where the benefit landed, where the loss was felt, how would you argue a court should weigh those different locations? Which factor should matter most? Something to ponder.